why this court should stop them from taking those steps. And as the Constitution...
do you agree with the suggestion co-counsel made that maybe they're waiting and hoping we'll bail them out?
I would doubt that, Your Honor. I would assume that if they, in fact, are going to change this law, and as long as they deem it fit after hearings, and as Your Honor has pointed out, there is no definite empirical data. Maybe they're waiting for that. Maybe they could have hearings. They can have other people come in and explain to them how maybe this law can change. However, this court should allow them the chance to examine the law and whether or not they should change it.
Thank you.
Thank you, Your Honor.
Ms. Summer.
Thank you. Well, there's a lot I'd like to respond to. I know, though, that much of it was addressed in our briefs and that Ms. Kaplan will be covering, especially the arguments that were made with respect to the rational review failure of this legislation. Let me first start with the Baker versus Nelson argument quickly. It really is an argument of such little merit that even Mr. Kerner's office, Michael Cardoza, in an opinion written March 3, 2004 that's in the record to the defendant in our case, Victor Robles, pointed out that, and this is at page 129 of the Hernandez record, that the appellate courts of New York have not addressed whether the statutory exclusion of same-sex couples from the opportunity to marry is consistent with the federal and state constitutions. And as recently as last year, the United States Supreme Court made clear that the constitutional question on the federal level remained an undecided one, citing Lawrence versus Texas.
Well, can't it be open for them and not for us? That is, isn't his logic right that if our equal protection clause is no broader than the federal equal protection clause, which we have said, right?
You have said that, yes,
okay, and if that's true, and if Baker v. Nelson has not been overruled by the Supreme Court, they may be ready to overrule it tomorrow, but we can't overrule it, can we?
Well, Your Honor, first of all, this court has said that the federal equal protection guarantee and the state may be no broader. However, it is in other situations, in other cases, and Judge Kaye has written an article in which she says this, there have been occasions when the court has certainly done an independent analysis and is not bound by the federal analysis. In addition, there have been subsequent doctrinal developments since Baker versus Nelson had its summary dismissal and under Supreme Court precedent.
Yeah, but I guess that's what I'm really saying is I assume you're right that there are doctrinal developments which make it possible, likely, highly likely that the Supreme Court would not follow Baker v. Nelson tomorrow. Are we free to say then, okay, Baker v. Nelson's no longer the law? Or doesn't the Supreme Court have to say that?
I think you're certainly free to say that we're going to construe our state constitution, put Baker versus Nelson aside, say Baker versus Nelson is not controlling precedent, as the Attorney General has said already in an opinion cited in our record, and as has been said by some lower federal courts cited in our briefing as well.
Well, we'd have to say the Equal Protection Clause in New York is broader.
Not necessarily, although not necessarily, because I think Baker versus Nelson cannot be viewed as good law or precedent binding on any court, federal or state, and certainly not on this state.
Well, I get back to Judge Smith's question. I mean, isn't it something different to say that they could change their minds tomorrow, but while that precedent is still out there, it's binding on us to the extent our Equal Protection Clause is coextensive with the federal one?
There have been two federal district court cases in recent years cited in our brief, the Smelt case and In re Can Do, that have themselves said that they don't view Baker versus Nelson as binding even on federal courts. So I don't think this court even has to go that far. And then I'd like to turn as well to
what do you extract as the binding equal protection jurisprudence of the Supreme Court of the United States on this issue?
Well, as the opinion I just read says, the federal law is still an open question under federal law. I think there are important cases, such as the Zablocki case.
So it's just a completely open issue?
There's a lot of guidance from cases in federal law, ranging from Griswold versus Connecticut, the Eisenstadt case, which held that the right to privacy and autonomy in making decisions about whether or not to use contraception was not just a right for married couples, but also a right for the unmarried, and required the court not to define a right in narrow group-based terms.
Do you agree with Justice Scalia that in Lawrence v. Texas basically makes it impossible for the Supreme Court not to hold that gay marriage is permissible?
Well, I certainly do believe that Lawrence versus Texas's teaching and the methodology it follows does mean that any fair application of due process and equal protection doctrine should lead to the conclusion that it is unconstitutional to deprive same-sex couples of access to civil marriage. Yes.
So when they said we're not deciding that and Justice Scalia said don't believe it, you think he was right?
Actually, I believe that what Justice Scalia was right about is that Lawrence is a case that makes very clear how other courts need to address the question of marriage rights for same-sex couples. I think that the Lawrence majority certainly didn't reach the question and was careful to make clear that it wasn't. But I also think Lawrence is important for questions that have come up earlier about whether we're asking the court to define a new right to so-called same-sex marriage, or to simply acknowledge that the right to marry, the well-settled fundamental right to marry, can't be defined so narrowly on group-based terms to exclude an historically excluded group. And in Lawrence, the court overruled Bowers versus Hardwick, which the Lawrence court said Bowers' description of the right at stake and in Bowers' court said it was facetious to claim that there was a right to homosexual sodomy. The Lawrence court said that misapprehended the nature of the right at stake. It was a right to individual autonomy in making decisions about one's private sexual relationships and bonds with another, and that it demeaned the dignity of lesbian and gay people. So,
had Baker relied on
Bowers?
Yes.
No, Baker predates Bowers. I'd like to also turn to the discussion about the Turner versus Safley case, because I do believe that Turner is a case that's very on point and important, and I don't think that it's fair to characterize it the way I heard it characterized earlier. I think Turner versus Safley upholding the right of a prison inmate to marry, it's clear that that prison inmate had no ability to engage in procreative activity, and if there's any question about it, I think we just look at the decision of the court below in the Eighth Circuit, which we did cite in our briefs, 777 F. 2nd 1307, in which the Eighth Circuit court rejected the argument that a restriction on a prisoner's right to go through the formal ceremony of marriage does not amount to an infringement on a fundamental right, because those aspects of a marriage which make it a basic civil right, quote, cohabitation, sexual intercourse, and the begetting and raising of children are already precluded by the fact of incarceration. The court rejected that and said, this argument ignores the elements of emotional support and public acknowledgement and commitment which are central to the marital relationship. Those words were echoed in the Supreme Court opinion in Turner itself, and make clear that it is simply a misstatement and a misunderstanding of what's important about the fundamental right to marry to say it hinges on procreative abilities or intentions. That's simply never been that has not been the law in any recent decades, and especially since Griswold versus Connecticut in 1965, when the Supreme Court said there is a fundamental right of married couples to use contraception, and they're no less married for having made that decision. I'd like to also clear up one other point. Ms. Kaplan said, and I think this is actually was a misstatement, that only heightened scrutiny applies as well to a fundamental rights violation, and that, I don't believe that to be the case. It is a question of strict scrutiny when a fundamental right is burdened to this extent. I'd like to conclude, racing against the clock here, to respond to concerns that this is a matter that should be left to the legislature. But when constitutional rights are at stake and the legislature is falling short of protecting them. It is quintessentially the role of the court. And this principle is of such importance that it has been memorialized on the very walls of this courthouse. Just in the next room, hanging in the library, are these words, never more apt today, and I'm quoting the Chief Judge here. The role of the courts as impartial protectors of individual rights can provoke controversy, especially in hard cases involving unpopular causes or litigants. Yet it is precisely because independent tribunals decide cases according to the law and not the opinion polls that so many, including vocal critics, immediately turn to the courts for protection and relief when their own important rights are at stake. The legislature can't pick and choose whose fundamental rights will be respected. They're the birthrights of all New Yorkers and must be guarded by the court for all of us.
Thank you, Ms. Summer. Ms. Kaplan?
Well, I'm a little tired at this point, Your Honors, but I'm going to try to speak as quickly as Mr. Kerner did so I can get through all my points. The Baker v. Nelson point, I think, need not detain you long. Take a look at the Onofre case. This court has talked about what the meaning of a summary dismissal is of the United States Supreme Court, and it said as follows. In that circumstance, the disposition by the Supreme Court does not necessarily signify approval of the reasoning by which the lower court resolved the case.
Well, but your adversary says that was after an analysis of the particular circumstances of that dismissal. I mean, but we know the circumstances of the Baker v. Nelson was dismissed for want of substantial federal question. Doesn't that mean what it says?
The Supreme Court has said the exact same thing about its own summary dismissals, Judge Smith.
So you're saying that a dismissal for want of substantial federal question is not precedent?
It's precedent, but it's not binding precedent on the reasoning of the court below. And the Supreme Court said exactly the same thing.
But it does establish that no substantial federal question was raised.
The Supreme Court dismissed it for want of substantial federal question at the time that Baker v. Nelson was decided. The Supreme Court, about its own summary dismissals, has said you can't rely on them for the reasoning below.
Not for the reasoning below, but I don't quite see how there can be no substantial federal question in Baker v. Nelson and there be a substantial question in this case.
Oh, I think that's clear. Baker v. Nelson, you can't rely on the reasoning below. The reasoning below was reasoning at that time.
Forget about the reasoning. How could one of the whichever party lost in Baker v. Nelson lose and you win?
Because the Supreme Court's basically said you can't rely on our summary dismissals as binding precedent that governs going forward on the reasoning below. It's not binding precedent, Your Honor.
Ms. Kaplan, if rational basis is the standard, why hasn't that been met here?
If rational basis is the standard, why hasn't it been met? It hasn't been met because every justification that's been offered doesn't work. Let me
try the procreation one, which is the one that has been so extensively urged by your adversary.
Let me be clear on procreation. First of all, we're not running away from procreation, Your Honors. We believe that there is, of course, procreation has something to do with marriage. But the problem with the procreation argument, it is, and I see Judge Smith, laughing, it has a lot to do with marriage. We can see that too. The point is that in the analysis this court does under the rational basis test, in Onofre, in McMinn, in Liberta, in Levin, it looks not only at the people who are included in the classification, but it looks at the people who are excluded by the classification. And to answer one of George Bundy Smith's questions, there are 46,000, more than 46,000 families in this state that are same-sex families with children. And there is no dispute here that there is no rational interest being served in procreation, in stable families, or in healthy children, happy children, and excluding those families from the benefits of marriage. If you look at the exclusion as you did in those cases, you can't conclude it's rational. There's absolutely no connection. Let me go to, there's been a lot of talk this afternoon about the legislature. The real question here, there is a bill pending in the legislature. It's been sitting for a long time. With all respect to the co-equal branch of government, it's not a legislature that's known for being the most activist in the country. This court knows that, unfortunately, all too well in the CFE case. But that's not really the question before you. The question before you, as Judge Kaye just pointed out, is whether there's a rational basis. If there's no rational basis, then this court must strike the statute, regardless of what the legislature is doing or isn't doing. Let me talk about tradition. There's been a lot of talk this afternoon about tradition. I think we can all agree that tradition standing alone doesn't meet the rational basis test. And the reason it doesn't, first of all, this court said it didn't in Onofre and Liberta. But putting that aside, The reason it doesn't as a matter of logic is because there's no difference between the classification and the interest. Yes, there's a tradition of excluding gay men and lesbians from marriage, but that tradition doesn't justify continuing the tradition into the future. There's no difference, and as the court explained in Romer, when there's no difference between the classification and the interest, that fails rational basis.
Shouldn't I mean, I see your point, shouldn't we have a certain humility in face of the fact that for centuries the classification has not only been made but assumed? I mean, that is, until 50 years ago, almost no one would have thought that marriage meant anything else than marriage between a man and a woman. Is that irrelevant?
That brings me to my next point, Judge Smith. I'm glad you asked the question. If it doesn't meet rational basis test...
Well, how about first whether